Hello, everyone. Good evening and welcome to the pre-event show of Turnip Innovation Festival 2021. As you might know, our main event starts next Friday, 10 a.m. and lasts for 2 days until Saturday, 6 p.m. So I will speak about TIF 2021 at the end for 5 minutes and answer all your questions. So please stick around till the end if you want to know more about the Turnip Innovation Festival or you want to interact with me. You can also check out the links in the description for more information regarding the Turnip Innovation Festival. So today, we have with us Dr. Prachi Pandey. She is a professor and IPR coordinator at BITS Edu Campus, Vadodara. She has 15 years experience as a registered patent agent. She has a postgraduate diploma in patent laws from National Academy of Legal Studies and Research, Hyderabad, with first rank in the country. So folks, she is truly a leading academician, IPR academician in India. So make use of her time, interact with her, get your queries answered. And she's going to talk about the different types of patents in India. So, many inventors and scholars, they don't have this much, understanding of, what kind of patents they should go for and what are the pros and cons of each. Some of you might know that she will also be speaking in the main event on patentability, which is a topic that stumps even the more experienced in the field. So with this introductions, I invite Dr. Prachi Pandey to join the stream, and enjoy everybody.
Yeah, good evening to all the innovators and students, faculty members, all the startup aspirants. A very good evening to all of you. And I hope you all must have some kind of good innovation in your hand. And today you must be very curious to know about how to protect it. It's very important to protect your innovation. And whenever you do something very novel, very unique, which is very industrially applicable, then it becomes equally important to protect it by applying the proper protection through intellectual property rights. So today I am going to explain about the types of patent applications through which you can protect your innovation in India, in world, or you can have many options of protecting it. So we hope we would have a very nice interactive session. It's you all are very much invited to ask questions, clarifying your doubts, and we can proceed in that way. So let's start. So I'm sharing my screen with you. So let's start how it works and how actually it happens. So just see here. First of all, you will see whenever we have something which is very industrially applicable, industrial property, then we protect it by intellectual property rights using patent, geographical indications, trademarks, or layout designs, trade secrets, all these things. And whenever we have some literary, artistic work or any written matter, we protect it through the copyright. So patents are what? These are the exclusive statutory monopoly right. Monopoly right means it becomes yours, your own property. So it is granted for a limited period of time to the patentee by the government. Limited period is 20 years. And in exchange, the innovator now disclose his full innovation, his full invention. Clear? So patents are territorial rights. Whenever we apply for a patent in India, our rights are there in India only. We can market in India. But we have to search all over the world that it is not a prior art, means it should not be reported anywhere in the world, because only we have to prove that my innovation is novel. Novel means new, never done earlier. So to prove this concept, we have to find that our product must be protected in India, but it must not be reported anywhere in the world. Okay. So for this reason, we say that patents are territorial rights. Then patentable subject matter, we can say that it should be very novel, unique. It must have innovative steps in that, and it should be industrially applicable. Okay. So inventions which are not patentable in India are whenever you have a scientific theory or a scientific principle or a new property of a known substance, such as if I'm saying that aspirin, I will apply it for treatment of some like anti-diabetic drug or something, like a new property, new use, it become not patentable. Because not patentable, but there is a clause, unless until I can prove that my aspirin is a very potent anti-diabetic, I have to prove the efficacy. In that case only it will be patentable. So any new property, any new use, any new salt form, any such kind of matter is not patentable. Mere arrangements are not patentable. Any innovations related to atomic energies are not patentable. So I think my slides are visible to you. Just a minute. Just a minute. So, what we say, I think my slides are visible to all of you. So, we say that we have a certain criteria to file a patent and to protect our innovation. Who are eligible to file a patent application is any person which claim to be a true and first inventor of the invention, or any assignee or any legal representative. So, we will see here steps in filing patent application is like whenever you have any good invention in your hand, you file a patent for that. Okay. And you will have your inventorship rights in your hand. Your patent is in territorial jurisdiction, means if we file a patent in India, we can have the marketing rights in India only. But for qualifying for a patent, it must not be reported anywhere in the world, because patents must be novel. So that is a clause. Patents can be filed individually either or through a patent agent. And regarding patent filing, we can have a system of invention disclosure by which we can disclose our innovation in a full way so that anybody can see the innovation and can prepare it. In that way, we have to disclose. We have to do the patentability search to establish that my innovation is novel. It must not have reported anywhere in the world. Then we draft the patent application. We can go for national filing and can go for international filing. So here we have our types of patent is applied whenever we have a national phase or a international filing. This is a different thing. So see here, what are the steps? First of all, we disclose our innovation in terms of description of our product, diagrams, or experimental results. Then we have to search the novelty. Novelty can be searched in many ways, such as freedom to operate search, novelty and patentability search, patent prior art, validity or invalidity search, and patent landscape search. So freedom to operate search is what like to find out exactly commercial production, marketing, uses of the new product, so that we should not prepare the same. If you have some idea in your mind, the same idea can come in many people's mind, and may happen that both of you or many of you might be preparing the same kind of product. So it is very important to search that the same product must not have been prepared earlier, even by mistake, or even by like similar ideas came in all of the minds. So it should be very sure that the product what have been prepared earlier must not be repeated by you. So you must search it. If it is repeated, definitely you can't file a patent, and you have to make more modifications, or you have to like make a more better product. You can add some innovative steps. You can make it more technically advanced to make it a product that is patentable. Novelty and patentability search is important to find out the novelty. Novelty simply meaning, I told you, it should be new. It must not be reported earlier, and it should be non-obvious. Non-obvious means, suppose if I'm telling that you are just joining an umbrella to a fan or joining umbrella to a torch, and They both are working independently. Actually, our efforts are nil. We have just did some arrangements. So it become a very obvious innovation. You have to make a non-obvious. Means it should look like innovative. Should look like that you have imparted a good innovative idea. You have incorporated your human efforts, and that's why it is becoming a very non-obvious innovation. Then we have to search for patent prior art. Whatever is reported, what is the status of technology? Am I the same? Am I the similar? Or I am the better? So patent office will consider you only whenever you are better in terms of innovation. You know, invention is done for the first time. Whenever you add some good concepts, make it more technically advanced, it become innovation. So how you are better than others, how you are technically advanced, how you are reaching a full gap, means crossing a full gap and reaching far beyond. So it's simply meaning it should be better than the already reported. So that is a patent prior art. And if it is really better, then the grant of patent is also very easy. Clear? Validity search means it is conducted after the grant of patent to determine the novelty and inventive step of the patented invention. Validity or invalidity search. After the grant also, if somebody claim that your patent is not valid, or even after you have your product in your market, somebody can prepare the same product and claim that your patent is invalid. Or so for that we have to do the validity search or invalidity search to find out that we should have good inventive but sufficient inventive concepts of the patented invention. That is a validity search that is done after the grant of the patents also, so that we can sustain in market. You know, for sustaining in market we have to be always better technically advanced. Patent landscape search is done to get an overview of particular technology specific development in the industry in a very broad way. So these are some kind of search that is normally being applied in the patentability search. Now the point comes is the type of patent applications in India for which we have gathered here to know more about it. So first of all, the application is ordinary application. That is a provisional or non-provisional. Now I'm telling you what is a provisional. Suppose today an idea has came in your mind that yeah, I can prepare this, and yes, I have resources. Yes, my product is better because I have searched the earlier patents, and yes, I'm sure that I will be preparing it. So once the idea come in your mind, what to do next? Never share with your friends, never post it on social media, never tell it to anybody. Just file a patent. Okay. Once you file a patent in Indian Patent Office, you will get a priority dating. Once you get the priority dating, simply meaning Patent Office is now aware of your innovation. Clear? And now this priority dating become a major war weapon, you can say, in the field of patents, because in India there is a system of first to file. Those who have filed first will have the right first. Okay. So rights will be to the person who has filed first. So first file the patent. Now you have 12 months of time to actually work over the idea, to prepare a product, and to file the complete specification. Complete specification contain all the details about the product. Okay. So all the details are what? I'm going to the next slide so that you will be more aware about the provisional and non-provisional. So provisional, non-provisional, both are called as the ordinary application. Ordinary means what? We are applying in just one country, India, not claiming our marketing rights in any other country, and I'm going to market only in this country. This is an ordinary application. Can be filed by a natural person like any student innovator, anyone which is a natural person, or an organization or a startup. The fees are different because for natural persons and startups fees are very less, because there is a system of 80% rebate to students or startups by the government of India as compared to the bigger organization. So you will be in a huge benefit. So fees are very less, just 1600 for e-filing for your provisional application as well as for the complete. So these are called as ordinary application because we are filing in a single country. So after filing provisional, within 12 months, the complete application must be filed. What a complete specification should contain? Now it's very clear that provisional contain just a very brief about your project, like your title, your technical field, what you are going to prepare, your plan, your objectives, small descriptions, a small abstract. Abstract is important in provisional. You have to mention the abstract and then file the provisional application. Once you have prepared the product within 12 months, go for filing complete specification using the following details: title, preamble, technical field, background of invention. Background, I already told that background is what? It's a prior art. What is done earlier in the past. Clear? Then only you can prove that you are better than the past. So, background of invention, what has been done, object of invention, what you are going to achieve. It's very important. Nothing can be prepared without an objective, without a plan. Your plan is to cater the needs of this, to solve the problem of this. Objective should be written like this. Statement of invention, exactly what you are going to do. Then if you have some drawings or sketch or a product diagram, then you have to describe it with the help of labels. So there should be a full description of the drawings. So in a single drawing, what are the different parts that should be described? Okay. Then detailed description. Detailed description simply meaning what would be the process of preparing, what would be the composition of your product, what would be the, suppose if it is a mechanical instrument, a helmet, a wheelchair, what are the parts, how they will work, how, and remember, all should work in coordination. This is very important. You cannot just assemble some parts and claim that it is a patentable. No, all the parts must support each other to make a single innovative concept. Okay. So suppose if I'm giving an example, and a umbrella and a torch. Suppose whenever it is dark and you open an umbrella, torch itself gets means like it gets switched on. Simply meaning, because of this opening of umbrella in dark, the torch itself gets like lit. Simply meaning they are actually coordinating each other. So whenever they coordinate each other or support each other to make a single innovative concept, then it become a patentable invention. So exactly we have to say everything about it in the detailed description. We have to draft the claims. Claim drafting become a very important part, because what you claim in your innovation become your marketing rights. If I claim my product has this formula containing this composition, it means this is your composition. Nobody else has prepared it and you are claiming it. So once you enter the market, nobody else can prepare the same product using the same formula. So you have to claim it very meticulously, what exactly the product is, what exactly the process by which you are preparing the product. Clear? And all things must be written in a way that is very precise, very accurate, and what do you want exactly. So suppose if I'm saying my product is containing this much percent of component A, this much percent of component B, then Y percent of component C, nobody else can prepare the same formula. So you will have your marketing monopoly over that product. Then comes the abstract, that written just as a summary of your product. Now I'm telling you why it is called as ordinary, because it is just filed in one country without claiming the rights in any other country. Okay. So it is an ordinary application. Now I'm going back. The another application is convention application, PCT international application, and PCT national phase application. These three are called as the international applications. Why they are called like this? Why? Because you are claiming priority not only in India but in other countries simultaneously. Not like to go in separately in other, like many countries, and now going in other country. There is a big system prevailing through many of the conventions, many treaties, so that once we file a patent application in one country, we can simultaneously like claim our patent in multiple countries. So how it work, we will see here. So we will see the three types of international patents, which are convention application, PCT international application, and PCT national phase application. Now how it works, just see here now. So convention, Paris Convention, a convention agreement has been done in Paris, and there many countries took part in that, and they decided, like, once I file my patent, suppose in India today as a provisional application, okay, I'm filing within 12 months my complete specification, good, and I'm mentioning here that this is a convention application, so I can claim the priority in all the member countries which are the member of the Paris Convention. Okay. So simultaneously, I can have the protection in many countries. The country that I want, I have to designate the country. Suppose today I have filed in India. Within 12 months, I have filed in India only. From the date of filing of my first application, I can enter in any country. So filing of patent in one convention country and claiming the priority simultaneously in all the member countries of the Paris Convention. Okay. So it happened as a Paris Convention. Suppose today I filed in India, within 12 months I can enter in any of the countries. This was a simple process. The another more advanced process is the PCT, where you have many advantages. You have to file in a single country, in a single language, a single patent application, and you can claim the priority in 152 countries which are the member of the PCT, that is the Patent Cooperation Treaty. So this is an international application. Now how it works, just see here. Today suppose I have filed in India a provisional application. An idea came in my mind, and I just filed through e-filing one patent application in India, Indian Patent Office. Now I have 12 months to like work over the product, and now I have the complete specification in my hands. What can I do? I can file an international application, or it can be filed in India also, because India is also a receiving office for international application, or it can be filed in International Bureau of WIPO. So International Bureau of WIPO receives this application. So normally what is done, whenever we file in India, suppose you are not filing provisional, you have your complete specification in your hands, and today you are filing your complete specification in India. After 6 weeks, you can file international application in IB, International Bureau of WIPO. Why? Because there is a lapse of 6 weeks by which the communication takes place. So after 6 weeks, but within 12 months, this is the time, you can file your complete specification in the form of international application in IB. Clear? Or also in India, because India is also a receiving office, there also it can be done. So this is your international application. You have to mention in your patent application, it is already there, you have to just tick it, yeah, I have to go through the PCT route. Clear? And you have to take the permission of foreign filing in the filling the form 3. Now the international phase starts. After 16 months, the transmittal of international search report and written opinion comes. What is the advantage? What is the beauty of PCT system? You see here, the innovator will get a patent search. Clear? Innovator will get a preliminary examination also. So the country you can designate for your search as well as for examination. Suppose if I am designating India as my search authority or examining authority, then it will be searched and examined by Indian Patent Office. I can designate some other country too. Okay. So after 16 months, the transmittal of ISR and written opinion, international search report and written opinion comes. At the end of 18 months, we have our international publication. Clear? So our patent application is published at the end of 18 months. Clear? And we have our international patent application published. Clear? Now, what happened? At the end of 19 months, applicant can request supplementary international search, like supplementary search. If the applicant want that my patent application should be searched thoroughly by international search authority, it can be searched. Clear? That is a facility given. There are fees for that, definitely. But for India, because India is a developing country, there is a 90% discount over the fees. So it become very less whenever an Indian file a patent application through PCT route. You always see, if it is a 90% reduction, you can say that everywhere it is becoming very less. Okay. Filing fee, search fee, examination fee, everywhere it is a 90% reductions. So the fees become very less for Indians because India comes in the category of developing countries. Okay. So after the end of 22 months, applicant can file a demand for international preliminary examination, and the examination report come. Innovator can become very sure whether my product is really novel, based on the search, based on the examination, and he can be very sure, yes, my product, whenever I enter in any country, yes, it could be patented because they have crossed all the process of this search and examinations in between. So at the end of 22 months, the applicant has the examination report in their hands. The time lapses, transmittals of IPRP, International Preliminary Examination Report, all comes. And now at the end of 30 months, the national entry starts. So see, after filing at 0 month till 30 months, the applicant has time to see their patent, fate of patent. Their patent is being searched thoroughly by the international organizations, international bureau. They are being examined. Okay. So all processes are going so well. Now they will be very sure to enter the different countries. If they are very sure, yes, their results are very promising, I can select US, I can select Australia, I can select UK, I can select many countries at the end of 30 months and can enter the national phases. So national phase entry means once at the end of 30 months, I have to file another patent application for granting US, for granting UK, for granting Australia, as many as country as you want. 152 countries are there. Suppose what happens if, like, at the end of this 22 months, or after getting your search report or examination report, if a applicant be sure that yes, there are some like loopholes in my patent, it's not so patentable, search reports are not so promising, or examination suggests that yeah, there are it's not so novel, it is not so industrially applicable, then they can just withdraw to enter in all countries. If they have little scope, they can enter in just one country. So this time is being given, and just one application has been given, has been filed, first in Indian Patent Office, after 12 months in IB either or in India, and then you see the fees are also very less, and you have a 30 months time to think over it and then to enter the different countries. So if suppose a patent gets rejected, then there would be loss of money, but still you can see till the 30 months you have lot of search programs, lot of this examinations are going on, and it really like at the end of 30 months the innovator really becomes sure whether to enter the which country or whether not to enter. So here they can enter the national phase. What would be the priority date? That's the beauty of the PCT system. The priority date would be this date, that is the first date they have filed in India. Remember, now you have the priority date of the first application. You have already very much ahead. So you are already very novel. Novel means what? New. New on the date of filing. Okay. So you can claim the priority dating as the 30 months earlier priority dating. So definitely whenever you enter the national phase at this level, you are very novel, you are very new, because your priority date is what? The first date of your patent filing. And now you have a scope of entering in 152 countries simultaneously. So the process goes on like this. Whenever invention come in your mind, you file the international application directly. If you have the full data ready with you, file the international application. Clear? It takes about like 6 weeks to reach the IB. Normally, they give a like 6 weeks time, and after 6 weeks, you have to file in International Bureau. International Bureau receive it, then they publish it at the end of 18 months on the patent scope website. They communicate to designated offices. Here, the countries could be designated. What country you want to enter. Okay. So once the countries are designated, your report is being sent to different countries. Okay. And now it's your choice to enter in which country. And now the grant could be, suppose in 6 countries the patent is granted. See, for industries which are actually a very novel product, if they have the patent rights in more than 6 countries, see what wealth can be generated from that. So in different, simultaneously in multiple countries, they have their own patent applications. Another part come is the patent of addition. Patent of addition, what happened? Somewhere you have filed a patent application. Clear? But suddenly you realize that some more improvement can be done. Another case, you have your patent in your hands. Patent is granted. Then you realized that some more improvement could be done in that. So what to do? Patent of addition is a remedy for that. You can file a patent of addition after applying the patent and also after the grant of the patent. So it contains more information, but within the scope of your patent. Suppose if I'm saying I'm preparing a sustained release matrix tablet containing the pH sensitive polymers to achieve a release retardation for up to 8 hours or 9 hours. Now I realized after application or after the grant also, after the grant, after so much time also, that this polymer could be not this, but another could also be used. Suppose I had used Utrajet, some grade. Now I have realized that no, Utrajet RL100 or RS could be a better one. So what I did, I have applied for patent of addition. So term of patent of addition will be the same as my parent patent. It will expire on the same date as my parent application, the first application. And there would be not be any renewal fee. There will not be any extra fee need to be paid. Means it will be just a hand by hand patent along with my parent patent application without paying any renewal fee. So that is a very good facility given by the patent office to the innovators. So whenever you have some more something come in your mind that some improvement could be done, so never be like disappointed that I have not filed, I am not included in my patent. Yes, there is a scope. You can file the patent of addition. You can file a separate application mentioning the date of your parent application, and yes, the term would be the same as your parent application. You can file even after applying, you can file even after grant. Okay. So these are additional information, but remember this should be only a complete specification mentioning the date and patent number of your first application or the parent application. Okay. So this is the patent of addition. This happen normally from the side of innovator because idea come in their mind. But another application, that is the divisional application, where ideas somewhere come in the innovator mind and somewhere it is done because of objections raised by the controller. So what is a divisional application? I'm just giving you an example. Suppose if you have prepared a product, suppose a mechanical engineering student have prepared a smart helmet, clear, along with a smart bike gear, along with smart shoes. Okay. So all these are what? To protect. Purpose is the protection. But what they did, they have filed a single patent application and covered all of them. Means the helmet, the bike gears, and also the shoes, protective shoes. So later on, they realize my all inventions are protected in a single patent application, and it is not so elaborated well. So before the grant, remember always, divisional application is applied before the grant. After the grant, it is not possible. So before the grant, if innovator realizes that I should divide it, why not to file a single patent application for helmet, then single patent application for bike gear, and another for shoes? This comes from innovator mind. Okay. Suppose so they can file the divisional application. So divisional application can be filed using a complete specification, and we have to mention the date of our parent application, that I'm dividing my application, and now I'm filing a separate application for my bike gear or the shoes, separate from the helmet. So this become a divisional, so they can do it after filing. Okay. But suppose during examination, the innovator thought that no, why to file different patent applications? Why to pay separate fees? I will file a single application and I will pay a single fee for all my three products. But here the point comes, if suppose controller has the objection. So whenever examination of patent goes on, controller examine the patent application thoroughly and then find that why this person has applied for three products in a single patent application. So the controller raise the objection and say that file separate applications. So in separate applications means they say that file three patent applications, pay the fee three times. But yes, there is a privilege to innovator that the date of filing of all the three applications will be the same as the parent one. Okay. So priority dating will not be shaken. Priority date will be the same. Okay. This is called as the antedating. Antedating means we are going back to the date. So we have the three patent applications on the same date, that is the date of the first patent application, and they expire on the same date. Okay. So expiry will happen together. Patent will expire on the same date, and yes, there would be separate renewal fees. Not like the patent of addition, they become three separate patent applications, three separate fees for filing, all processing, and three separate renewal fees every year. I think you must be aware that for keeping our patent alive, we have to every year file the renewal fee for our patent. So our patent must be kept live. So renewal fee will be paid for all the three applications. So it can happen whenever a innovator itself decide or the controller decide. Controller may raise the objection. Okay. So it can happen for the divisional. So I'm always suggesting innovator that always think about it. Definitely if your products are linked together, but I cannot say that a helmet is actually linked with your shoes and then your bike gear. It is not linked. They are working independently. Helmet is actually protecting your head, or some smart helmet project is a very good project where whenever the helmet is being put on by the driver, then only the bike starts. This happened. So it was the beauty of the helmet. So this can happen with the divisional application. So this just I want to know if some questions are there, because I just want to have a very interactive session with you. So if some questions are there, I'm just seeing it here. Okay. So if any question are there, I can I'm very happy to answer your questions. If somebody has any question, please ask, so that I can elaborate you more, or I will be also able to know that exactly are you getting my points, or so now it's your turn. Please ask questions. So one question I'm seeing here from Kalpana Singh Solanki is expiry date of patent of addition and divisional will be the same date as of the parent application. Yes, It will be the same. They will expire on the same date as the parent application, even if it is filed later, but they will expire on the date of the parent application. Then just I'm going to the slide of the type of patent application so that you can see. Okay, another question by Zawad Galambor. So sir has asked, how much is the chance for getting patent for qualitative concepts? Actually, qualitative concepts chances of getting patents are less, frankly speaking, because unless until you have a tangible object in your hand, patents are normally not granted, because qualitative concepts become a literary work or a kind of novel written innovation. But for getting patent, you must have something that is working, actually, that is a tangible one. So tangible assets are very readily patented. Qualitative concepts are normally not patented. Concepts actually not patented. Ideas not patented. So this become, idea has to be transformed into products. PCT means Patent Cooperation Treaty. Patent is never an imagination, never intangible. If some imagination is there, written very beautifully, go for copywriting it, definitely. Then comes what is NDA? That is non-disclosure agreement. How will draft it? Non-disclosure agreement is a kind of agreement signed between your patent agent and yours, or to whom you are actually revealing your product. For suppose if you are like collaborating with some industry for preparation of your product. So what happened is, like in non-disclosure agreement, everything about the name of the partners who are involved, their designations are there, the date of disclosure, the part of disclosure that you are disclosing, an agreement that they will never disclose it to somebody else. That all has to be drafted. There is a proper format of drafting a non disclosure agreement. So yeah, that could be a separate session for that. So definitely I will be happy to tell you about that also. Ma'am, we are Dr. Sudhakar Bansod. Ma'am, we are heard the filing of application fee is very high. Which one? Actually, Indian filing is very less. For if you are an individual person, I just told that 80% rebate is there. So filing fees are very less. It is just 1600 for filing. 1600 for just filing the provisional as well as complete. Then if you are going for publication expedited or examination also, it's not so high. International also, I told you that in India is a developing country, so you will have a 90% rebate over the fees. So normally they are in dollars, but I can say you that after 90%, your cost would be nearly 25-30,000 if you filed it very individually. So it's not so much even if you go for an international application. It's not like that, actually. It's because of unawareness. Indian government has done a lot. Even the world WIPO is doing a lot for innovators and all the support. Our IT solutions or digital ideas can be patented. Subhanshu Singh has said, yes, IT solutions or digital ideas cannot be patented unless until you use those IT solutions or ideas to support a product. Means to prepare a product. Suppose if I'm using computer software to prepare a very efficient rubber molding machine. So that is actually the first computer software patent that is was patented. Clear? So not only idea. If you are writing a computer software or solution, it become copyrightable. So use it for preparing a product or support a product like a hardware. Then what about international patent? International patent is the just I told you, that is can be filed through convention application either or by PCT route. Both are that. What is the PCT route is that you will have the facility of search as well as you will have the facility of preliminary examination. So this will give you a full confidence whether to enter the country or not. Suppose you are not very sure, why to enter in different countries and lose your money? No. So PCT is like a single application. single language, single country protection in can be shot in 152 countries together. Okay. So another question, can we patent new teaching methodology? Sir is Manoj Kumar Gelda. New teaching methodology can be copyrightable, sir, and any new way of presentation, teaching method, teaching pedagogy, these are all copyrightable matter. Patent should be for a product or a process in India. Then question come from Sabiha Zaveen. During PhD, can we file? Definitely, Sabiha. PhD is a big innovation, so you should definitely file your patent while doing your PhD work. So first file your provisional, wait for your more findings to come, and then go for filing complete specification. 90% discount on Kalpana Singh Solanki has asked, is 90% discount on international application applicable for startup or MNCs? For individuals, it is applicable as per my information. MNCs, no, because MNCs are bigger companies, so no discounts for MNCs. But for small startups can be considered, because startups come in the category of individual person, but not MNCs. Now, Anvesha Banerjee has asked, can a patent be filed in multiple jurisdiction? Will it be PCT international application? Yes, Anvesha. Multiple countries can be covered through PCT route. Even through convention application, it can be covered. But you have to mention, whenever you file in India, you have to mention in your patent application, yes, I will go through the convention application or through the PCT route. And then you have to tick in that. There are many, like it is already written in your application. You have to tick. And then you have to fill the form 3 and report to Indian Patent Office that I am going to other countries also. Clear? So another question, can we file? What is copywriting? Can you please explain? Copyright is a big topic. Just in short, I can say, whenever you have a very novel, unique way of writing, means like if you have written a SOP, a computer software, a poem, a picture, a drawing, a sketch, anything on a paper, fix it. Whenever you have a poetry, do not sing, fix it, record it, and then go for copywriting it. So anything that is copyrightable, and yes, there is a separate website for copyright filing also, through which you can register your copyright. Fees are also very less. Even for like documents, it is 500 to 1000, 2000 maximum is there. So you can definitely copyright your literary works. Now the question come from Sukhwinder Sharma, that is difference between patent filing yourself or through patent agent, any priority, how difficult to file yourself? Okay, what happened, Sukhwinder, whenever somebody file individually, filing can be done, but the prosecution, the steps, the publication, examination, somewhere it become difficult for an individual because they are unaware of the sections, like 146 section, 131 rules. It's not easy to be remembered. So I think you should hire a legal professional patent agent who can really guide you in filing, publication, examination, because it's a totally techno-legal field and it requires many legal like sections, subsections, which can actually support your project. So it's like that. Now, another question from Sukumaran Prabhu. After 18 months, how do I know that my patent is published or not? Yeah, definitely. You can search the Indian Patent Office website. Normally, nowadays, they are giving a status also at the bottom. You can see the status of your patent. So what you can do, go to the Indian Patent Office website, that is www.ipindia.nic.in. I'm just writing here in the chat box. So at this website, you will find the patent. You will go to the status of patent. Clear? And in status of patent, you write your application number. It will give you the status, published, or wherever the status is, it will give. And then if it is published, you can see your full published application. It is on the website. It's very easily can be retrieved. So that can be done. One more question. From Deepa Charath, is there any standard format for provisional filing? Yes, Deepa, there is a proper forms Form 1, Form 2, Form 3, Form 5 are there. If you are hiring a patent agent, Form 26, there is a full forms. These are all legal documents, and forms are available on website. But you need to understand it well before filing, because this is a little bit like more to understand and then to file it. So there are many forms available. Form 1, Form 2, Form 3, Form 5 are mandatory. Form 5 are mandatory only when applicant is not an inventor. Otherwise, no need to file. So just remember Form 1, Form 2 and Form 3. These are necessary to be filed along with provisional as well as complete specification. The question from Sajid Siddiqui comes, can we file patent in social science research? So Sajid, simply I'm saying, if your social science research is developing a new process or developing a new product, then definitely it can be patentable. If it is generating a good report that is very unique, never been generated before, go for copywriting it. Now, question comes again from Sukhvinder Sharma. Any comments on Australian patents? Are they good? Why grant time is only a few months? Yeah, it comes like, many times I also see that people are filing in Australia because they take permission from Indian Patent Office for foreign filing and go in Australia. It simply meaning you have a marketing monopoly in Australia. So you can market your drugs in Australia. Their patent procedure are very simple, so they are giving you the rights. Simply meaning I can say that whenever something is very simple, not stringent, you can think over it, nothing else. So Australian patents, simply meaning you can market in Australia. But what I can say is, like, the market is US, UK, even India have a good market. If you wish to market in Australia, but I am not very sure about the wealth generation that you can get it from Australia. So Indian patent and Australian patent difference from Muhammad Iqbal. The sir is asking the question. So Indian patent simply meaning you can market in India. You have the market monopoly in India. Australian, you have the market monopoly in Australia. Patent is totally a territorial right. Only through PCT route or convention route, if you are designating the different countries and entering the different countries simultaneously, then you have the rights in all those countries. So, if you have a very good project in your hand, why not to market in world? Why not to generate the wealth from the world, not only from India? It's very important. Chinese people, they have patent filed all over the world and they are generating wealth from them. We Indians think that to file in India, why to go internationally? No, but you should go because your projects can be internationally recognized, and just have a faith on yourself. Why not to file? So, for question from Sukumaran Prabhu, for protective effect of a phytochemical could be patented. Okay, so phytochemical, if you have prepared a protective effect, it means it's a new use of a known phytochemical. So as per the section 3, it is not patentable. So for making it patentable, for proving it to be patentable, you have to prove the efficacy. Means you have to do all the in vitro studies, if possible do some in vivo studies, prove the bioavailability, prove the that it has a protective effect which is very good, and it is really can serve the purpose, then patent office can be convinced. Because a new use, simply section 3D says that it is not patentable, but still you can try. So you should have enough data in your hand to support it. So explain difference between patent of addition and divisional in brief. From the question, knowledge is power. Okay, so patent of addition is improvement in the already existing. I just said I have used many polymers, and I'm preparing a sustained release tablet only, nothing else, but I'm just changing the polymer or enhancing the concentration of polymer because I'm thinking that this concentration could be better, but I forgot to mention or I couldn't do because of some reason, then I can file patent of addition. Divisional means there are two different products which I have filed in a single application. Suppose I have filed sustained release tablet, then a delayed release tablet, chronotherapy modulated tablet, all together in a single patent application. Then I may divide by myself or patent controller may raise an objection and say me to divide during examination. They may say to file different patent applications. Why you are filing all those in a single fee? Pay different fees and pay different applications. This may happen. So divisional means divide your patent in 2 or 3, pay separate fees, pay separate renewal fees. Patent of addition, no separate fee, no separate renewal fee. It will be just as your parent application part. And both patent of addition and patent divisional will expire on the same day as the parent application. Clear? One question from Anvesha Banerjee. What do you mean by technical efficacy? How does one understand the term efficacy? Yeah, efficacy is a very subjective term. Efficacy means substantial improvement. If you are saying I am bringing 2% improvement from the existing product, controller may deny the patent. You have to prove a very substantial improvement. There are many cases where the especially in pharmaceutical field, where the efficacy is related to bioavailability. So 10% bioavailability they don't consider, 20% they don't consider, 30 somewhere they don't consider, 35, 40 somewhere they consider. So you can just learn from these examples, like you should have a substantial improvement, then only can be done. Clear? So I'm just going back to see some other more questions that if it is missed. Okay. A question from Param Jain. What to do when any other person find loophole in your patent and he files another with the same changes? Yeah, it happened. It happened actually. In many fields it is happening. Then you fight for that. You prove that. That's why I say everybody that whenever you do some innovation, prepare a proper lab notebook, jot down your finding with date and time, so that at least you can fight for your novelty, that I have done it earlier. I have done it earlier than you. So I'm reaching the patent office earlier than you. I have filed earlier than you. So I am entitled. First point is this. If somebody has made some changes, definitely go for an infringement suit. Court may impart injunction on the other party, or they may even can charge the damage, because somebody else might have marketed it in place of you. Somebody might have generated some wealth instead of you. So yeah, some damage can also be shot from there. Injunction can be there. First they stop them from marketing, then they can they can have to pay you back whatever they have earned. The damage has to be paid, means in amount they have to be paid back. It can happen. There's a proper legal remedy for that. So don't worry about it. Nobody can infringe your patent. There are full legal protection for that. But just you should know how to proceed. Just not be very unaware of all these things. So some more question I'm getting. One question from Sukhvinder Sharma. Can we get financial support from somewhere? Yeah, there are many government agencies which are giving the IPR support. I am also linked with the government of Gujarat for giving support related to IPR. So nowadays, now every government is very keen to give you IPR support. So they can even give you funds for IPR filing. So you can even contact your student startup and innovation policies of government. So they have many schemes. SSIP, you can see. They have many schemes through which they can fund your patent. Even you can contact DST or CPAM, CIPAM. They are or TICS. They are the agencies which are actually promoting the IPR in India. CPAM you can find, or if you wish to have some contact, you can contact me. I can give you some good contacts through which you can get some funds. So CPAM, and there are many bodies which are actually governing the or the promotion of the patent rights. PCT is Patent Cooperation Treaty. The question from I'm not able to pronounce the name. Okay. I'm just seeing the questions if somebody is left or. Okay, if any other question is there, you can ask me. Another question, what is the express patent in short duration? Yes, even in the 6 months, the patent can be granted if everything is done by expedited process. For examination publication, it can be done. So I think many questions have been answered. If some questions are not being answered because of the time is not so much, so you can contact me later also. We can arrange some more sessions. You can participate later, and definitely we can connect also in future. So thank you so much for such a patient listening. Thank you.
Thanks a lot, ma'am. Thank you so much. Really pleasure having you, and thank you for so precise answers that you've given. People I can see in the chat, what they are saying. Great, great. Thank you so much, ma'am. I will take over a little from now, and if anyone wants, you can interact with me regarding Turnip Innovation Festival. I do have one slide which I can show you regarding the conference schedule. So you will be able to, see the conference schedule. Yeah, I think I will remove myself, only show you the schedule. So this is the schedule. So you can see the keynote talk will be given by Mr. Munish Sudan from IP head of Tata Steel. Dr. Purushottam, with his 40-year career in NRDC, he has just retired 2 months ago. He's going to share, his topic name is not accelerated technology commercialization. It is success stories of academic technology transfer. So now he has changed his topic. So he will speak on the day one. Then there's a host of sessions. You can see Questel India is coming for prior art searching. IP Niti is one of our sponsors. She's going to talk about IP for startups in academia. Govind Kedia, he's a professional. He will talk about how to build a career in IP. And Tapan sir, he's 20 years experience in global filing and litigation. He will talk about secrets of claim writing. And some people were asking about copyrights. Actually, on day one and day two, we have 2 sessions on copyright by Shravani Deshmukh and Yashashwini Oja, who are co-founders of Create and Protect IP Partners. So they are, again, they have great in-depth knowledge of copyright, which you can use. And ITTO is also one of our sponsors, Technology Transfer Office from IIT Delhi. They are going to speak on a host of things where you can get funding, how you can use IP to get funding for your ideas. And they have also some sessions on day 2. So you can see also on day 2, Chandan Bhar, he has 25 years in big pharma R&D. So he's a patent leader in big pharma. And he's going to talk about innovation, healthcare innovation in post-COVID era. Dr. Himang Shah, he has also confirmed his session on design thinking for innovation. Make use of these things, guys. In the link in the description, there is a link where you can see the schedule. How 2 sessions, Ankit? Yes, that is the thing. No, you cannot attend 2 sessions at the same time. You can open different tabs, of course, of Google Chrome and attend 2 sessions. But by all means, you will get the recordings. So you will get the recordings. Say the event is on Friday and Saturday, so you have chance on you have chance to view all the recordings on Sunday. So this is the idea, that we have so many sessions. And yeah, let's see a bit more if you want. So Shuchi Agarwal and Ms. Mansi Chaudhary, they are going to have a panel discussion about boosting IP filing in academia. Again, there'll be a Q&A. These, they are top lawyers in India. So they are legally industry leaders who you can interact. You can talk with Lex Orbis, who's also one of our speakers, all about, filing patents, how to envisage the prosecution process and, not make mistakes which, these experienced leaders, they have already made. And yeah, I was telling you about the other session from ITTO. So key insights in academic technology transfer. So very, very focused on academics and IP. And again, Dr. Prachi Pandey, she will be here again to answer your questions on day 2. And it will be about patentability. So I think we will discuss about patentability and all the nuances of patentability that you can So folks, unless you have any questions, great. I'm seeing like a lot of good comments. Great session. Thank you. Like really, really, Dr. Prachi Pandey, she has been, doing a session with us earlier, and it was similar. The people were giving a similar feedback that, they had excellent presentation and organization. Thank you, Sukumaram Prabhu. Thank you, Rani Kiran. So folks, this is where I leave you. You can avail the full 2-day access of Turnip Innovation Festival for 249 rupees. And if you don't want to spend even 249 rupees, 4 keynote talks are included free of charge. So again, both these links are in the description. You can go for full access, which is taking you to the payment gateway. As soon as you pay, you get a confirmation. And you can also go for the free access where the 4 keynote talks. So I was showing you the 4 keynote talks. I think it's still shared. Let me try to share the screen again. So yeah, the keynote talks are Munish Sudan from Tata Steel, Dr. Purushottam from NRDC on day 1. And on day 2, it's Mr. Chandan Bhar and Dr. Hemang Shah from Qualcomm. So, you can attend these. These are, inspiration is the main focus. So our goal is to, use this as a tool for inspiration, this conference, and basically boost filing in academia, basically encourage more innovation and entrepreneurship coming from, academics. So great, Manoj, Kumar, thank you so much. I really appreciate your comments. And yeah, hope to see you in Anvesha Banerjee. You have patentability will be exactly the same time next week. So Anvesha Banerjee, please, I would urge you to register for the TIF 2021, and you will get the links on your email. So, so that session will not be public; it will be private, only for attendees. So yeah, it will be same time, 5 to 6 p.m. next Saturday. Great. So thank you very much, everybody. I wish you a great evening, and I wish you good luck, and hope to see you again in the next pre-event, which we are planning next week, and also maybe in physical conferences in the near future. So good luck and bye bye.